To neutralize the effect of Goloknath's decision, Mr. Nath Pai, MP, introduced a bill in the Lok Sabha on April 7, 1967, to restore the Parliament power to amend the fundamental rights. The proposed bill was justified as an assertion of the supremacy of Parliament, which principle implied the right and authority of Parliament to amend even the fundamental rights. The object of the bill was to restore the original position of the Parliament to make it explicit that Parliament can amend any provision of the Constitution by following the procedure contained in Article 368. Accordingly, in 1971, Parliament enacted the Constitution 24th Amendment Act, thereby inserting certain modifications in Article 13 and 368. A new clause was inserted in Article 13 which provided that Article 13 shall not apply to any constitutional amendment made under Article 368. As a matter of abundant caution, a clause was added to Article 368 declaring that Article 13 shall not apply to any constitutional amendment made under Article 368. The marginal note to Article 368 was changed from procedure for amendment of the Constitution to power of Parliament to amend the Constitution and procedure. Therefore, a clause was added to Article 368 providing that, notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation or repeal any provision of this Constitution in accordance with the procedure laid down in this article. The addition of the clause was designed to make an express grant of power to Parliament to amend any part of the Constitution, including the fundamental rights. It had been argued by Chief Justice Subba Rao in Goloknath that since Article 368 did not expressly authorize the curtailment of fundamental rights, such curtailment must be out of reach of the amending process. The amendment now excluded such an inference being drawn by expressly including the fundamental rights within the scope of the amending process. A view had been expressed in Goloknath that there was no difference between an ordinary law made under legislative process and constitutional amendment made under constituent power. To prove this point, it had been pointed out that the presidential power to assent or not to assent was similar in both cases, an ordinary law as well as a law passed under Article 368. The questions involved were, number one, whether the Parliament possesses unlimited power of amendment under Article 368. Number two, whether basic features of the Constitution can be amended. Number three, what is the content of basic features? In other words, what constitutes basic features of Constitution? Majority of 7 judges upheld the validity of constitutional 24th, 25th and 29th amendments, overruled its earlier decision in Goloknath's case. The court laid down that the power of amendment under Article 368 is unlimited. Parliament can amend any part of the Constitution, including the preamble, but the amending power should not affect the basic features of the Constitution. In other words, Parliament, by exercising its amending power, cannot destroy the basic features of the Constitution. However, the courts did not define the basic structure with mathematical precision, neither provided any guidelines so as to identify it. Majority of the judges observed that there are certain basic features of the Constitution which cannot be altered in by exercising the powers under Article 368. Constitutional amendment which seeks to alter or destroy the basic structure of the Constitution is ultra vires. The word amendment under Article 368 would mean changes other than altering the very basic structure of the Constitution. The court, in fact, did not define the basic structure of the Constitution in absolute and clear terms.